If men were angels, no government would be necessary. If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. A dependence on the people is no doubt the primary control on the government. But experience has taught mankind the necessity of auxiliary precautions. Certainly constitutional and American history scholars are familiar with these words that first appeared in print on February 6, 1788, and attributed to the Virginian James Madison on the behest of Alexander Hamilton, and that appeared in what had been called the Publius Essays addressed to the people of New York, many of whom had opposed the idea of a federal constitution. And today, most any legal authority would describe this essay in particular as the Federalist Number 51, perhaps most known for its exposition on a limited government of separate powers, an idea expressed by Justice Harlan in Jacobson v. Massachusetts, the smallpox case of 1905. But it also speaks quite a bit to another idea strongly promoted by Virginians like Reverend Jeremiah Moore, a reverend, just like Henning Jacobson in the smallpox case, who would later become one of the first pastors of the First Baptist Church of Alexandria. The first liberties in the freedom of religion that are contained in the Free Exercise and Establishment Clause in the First Amendment for the Bill of Rights, a primary concern from many early settlers of the British colonies, and that were adopted on December 15, 1791, over 4 years after the Constitution had been adopted on September 17, 1787. And if one were to simply follow the timeline, it would become clear that the first of the Federalist Papers would not begin to appear until after the adoption of the Constitution, to address some concerns raised at least by the citizens of New York. A collaborative effort of the founders, Alexander Hamilton, James Madison, and John Jay, and some others whose contributions were omitted when the collection of essays were finally printed in 2 volumes in 1788. 3 years before the adoption of the 10 amendments that comprised the Bill of Rights. And particularly for those engaged in legal research on constitutional issues, since these men were so intimately connected with the writing of the Constitution, the Federalist Papers assume the status of what are called primary sources in legislative history by attorneys to determine the intent of the drafters of that language which was contained in the Constitution and the Bill of Rights, which had placed first amongst an assorted collection of liberties contained in the First Amendment those guarantees against government encroachment upon what was deemed to be the province and realm of the various religious sects, who were delegated the authority for shaping the consciences of the citizenry. Very contrary to an idea today that it is the schools who develop value and other institutions, which was actually originally delegated to the churches, who were delegated authority for shaping the consciences of the citizenry, prompting another early founder, John Adams, in an address to the militia for the Commonwealth of Massachusetts on October 11, 1798, to state, "Our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other. 7 years after the Bill of Rights, he said this, with its recognition first of those liberties of free exercise in religion and against the establishment of a state church. First liberties that found some abridgment, even acknowledged by the governor of Virginia, Ralph Northam, in December, who had, upon his own admission, presented what were described as common sense. Common sense, not commonsensical, but common sense measures to address a once-in-a-century pandemic. Common sense measures. This history in American government and civics, and specifically the Virginian James Madison's Federalist 51, has a purpose which shall become more clear as we recall the great controversy in 1788 that had prompted Alexander Hamilton to seek the aid of fellow supporters of the Constitution to quell the dissent of the residents of New York, which was the home of many persons who were identified during the Revolutionary War as Tories or loyalists to the crown, a source of contention that found Governor Morris, delegate for the New York colonies during the Second Continental Congress, most often when voting to abstain courteously from matters called for adoption in respect for the opinions of the colonists who he had been sent to represent. And one famous New Yorker during that time of the fight for independence had been the publisher of a pamphlet in 1776 known to many today as what? Common sense. Like the common sense measures that had been implemented in Virginia by the Virginia governor, and which now is even the name of the last executive order on facial coverings. And in 1794, Thomas Payne published his first copy of a book that was known as The Age of Reason. Like the reason-based policies that are advocated by the Congressional Free Thought Caucus, whose invitation, according to the friendly atheist, Congressman Don Beyer, had finally accepted after his landslide election in 2020, and which had espoused a deist philosophy which had challenged institutionalized religion and had questioned the legitimacy of the Christian Bible. The Bible that has the antiquated codes, often noted by Hillary Clinton. The Bible that has been used by politicians to promote silly ideas, according to the Free Thought Caucus. A lot of people may not read history or have it as a ready reference, being myopic, especially in a pandemic when people are running for their lives. And it may be intriguing to find these competing ideas and themes that were present at the very beginning of the Republic, coincidentally, at least reappearing during an unprecedented public health crisis. Ideas of Thomas Payne that even are said to have influenced a certain German philosopher with whom many are familiar by the name of Karl Marx. And again, at least coincidentally, many of the activities of persons such as Governor Northam and even Captain Brett Crozier aboard the USS Theodore Roosevelt were of great interest during the public health crisis by a publication known as the World Socialist, which shares many Marxist ideas, just as many leaders of Black Lives Matter, who were very active during the public health crisis, have publicly admitted to be trained in Marxist doctrine and practices. And if your church was closed during the public health crisis, this might be of at least some fleeting interest, unless you would prefer to march with Black Lives Matter and be reported in the World Socialist. Well, let me tell you why I raise this topic. As some may know, I am both the son and grandson of Baptist pastors, as well as the godson of a Baptist pastor who became the House Majority Whip. and as a young adult, and had shared the same spiritual mentor that Reverend Martin Luther King Jr. had in Dr. Benjamin Mays, the former president of Morehouse College in Atlanta. I have two family churches on the National Historic Registry, but in the summer of 1975, with my family, I had the opportunity to travel behind the Iron Curtain, visiting Moscow, Leningrad, Prague, Warsaw, and Berlin. At a time when in the former Soviet Union, the practice of religion had been prohibited by law, and many former edifices that had been churches once in history had been converted to museums for historical and purposes and historical tourism, or repurposed for other commercial or government enterprise, like St. Basil's Cathedral, which is a prominent part of the Kremlin. And as noted by the Barna Group during the pandemic, 1 in 5 churches closed their doors forever, never to reopen again as churches during the pandemic. Many places of worship closed willingly because of a fear stirred by a novel coronavirus. And in psychology, there were 2 reactions to fear or ambiguity: fight or flight, with flight being most often the primary default. But when churches closed, when persons sought flight as a veteran military officer and who was once assigned to the Army Rangers, took an oath to defend the Constitution of the United States against all enemies, foreign and domestic, I went to challenge the violations of religious liberties in court, to which the Progressive Voters Guide can even today attest, where I am noted as having opposed the government response to the public health crisis. I brought the first and longest surviving challenges in court against both the lockdowns and facial coverings mandates, none of which have been mentioned nor appeared in the free press, a First Amendment right ordinarily subordinate to free speech in the Bill of Rights, but one that the members of the press or Fourth Estate are oft to herald as their own and present themselves as its champion. In total, I have 5 cases related to the government's response to the public health crisis, the last of which was filed against the vaccine mandates on July 7th, just after the celebration of Independence Day. It is a complex action with over 30 defendants, including the vaccine developers, various state and federal agencies to include the FDA and CDC, numerous public health officials, including Dr. Anthony Fauci, and assorted others who have been connected to the promotion of the vaccines and vaccine mandates, and contain a lot of scientific arguments that many persons unfamiliar with science may not and probably will not understand. However, one easy to understand argument arose against the White House, where we have named a few defendants, arises from a provision of the Freedom of Information Act, the measure first enacted under the administration of Democrat President Lyndon Johnson in 1966, a statutory provision for which President Jimmy Carter, a Democrat president, had announced in 1977 that the Department of Justice would not defend denials of records requested by American citizens, and a statutory provision for which, in his first executive order as president, Barack Obama, a Democrat, had demanded a preference for full disclosure. But in this action, the commitment of the current Democrat President Joe Biden has been put to the test, as since March 23, 2021, he and his White House staff have decided to refuse to respond to a Freedom of Information Act request. The deadline for that request expired on April 20th, 2020, and by July 7th, when our action had been commenced in the Federal District Court in Richmond, a judge who had been appointed by President Barack Obama could have, on her own accord and within her own discretion, ordered the release of the information immediately, even without a formal hearing. But that did not occur, and has not, even to date, occurred. The Freedom of Information Act request had simply sought to determine whether the infectious dose for COVID-19 which the CDC has admitted is not yet known, even after over a year, even though it is a relatively simple metric to determine what's classified information, and to determine if the secondary attack rate, which has never been published by the CDC, as it has for diseases like measles, chickenpox, and smallpox, was also classified information, because that too is a relatively simple metric to determine through cautious postulates, which epidemiologists and scientists have been doing since the 19th century. These are easy yes or no questions, classified or not. And whether something is classified or not is not of itself classified information. But the answers to these questions, very easy questions, raise very important issues that we shall attempt to explain in the simplest terms, because it is an issue that goes all the way to the highest levels of government and now to the White House. Under Executive Order 12958, signed by President Bill Clinton on April 17, 1995, the secondary attack rate and infectious dose for COVID-19 could only be classified information if SARS-CoV-2, a novel coronavirus, the reported causative agent for the disease condition of COVID-19, is the property of the United States government. And if it is the property of the United States government, under law, it could not have been the result of a zoonotic evolution, because you cannot own something that is a creation of nature, like Dr. Fauci, Governor Northam, and Blue Virginia, and others have claimed. There is considerable evidence to support the conclusion that COVID-19 is not an infectious disease being transmitted from person to person, including the 40-page report that had been published by the WHO in February 2020, which even its author complained on March 2nd he was concerned that no one had ever read. Published 1 month before the governor began the lockdown of the state and canceling of in-person worship. And if the government owns the biological agent that cannot be transmitted from person to person and can only be deployed, and that causes COVID-19, a 5-year-old, vaccinated or not, should be able to understand and determine that there is a significant violation of the freedoms that are guaranteed under the First Amendment for free exercise of religion and the Establishment Clause that has occurred for over a year. A discussion, if you are truly a person of faith or a pastor, you really need to have soon with your attorney. This briefing is unclassified. As you were, my name is Major Mike Webb, and by God, I am running for Arlington Public School Board. Let's keep Mike Webb away from our schools. Honest. Carry on.
This advertisement was authorized by Mike Webb.
Thunk, I could have had a vaccine.